let's kick things off for today. Firstly, I'd like to welcome everybody to our first webinar for 2022, Death Benefits and SMSFs, Planning for the Inevitable. Joining me today is Jason Poser, Associate Director and Senior Client Manager here at SuperGuardian. Welcome along, Jason.
Thanks, Tim. Looking forward to it.
Yeah, always good to have Jason on board. Just brings many years experience in the admin space. He did ask me not to name the number of years, so I've done that. I think I've obliged there appropriately. So happy New Year to you all. So today's subject matter, death benefits and the self-managed superannuation funds, and I guess the practicality of how these operate. What I've found is that it's an area that we all have to deal in at some point in time with our self-managed super fund clients. Now, in some unfortunate situations, you're dealing with it regularly, and in other situations, you're dealing with it on an irregular basis. And because of that irregularity, it's good to review it. And I find that this is a presentation that I would give on average at least once a year, and I would update it quite regularly because of changes in circumstances and changes in not just law necessarily, but also court cases and other things that occur. So it's a good way to start the year off talking about the practical elements of death benefits and dealing with them in the SMSF space. So, what I want to try and address is the issue of the practicalities. Now, you've got some issues with the sound there. We'll try and see what we can do about that, but hopefully from a recording point of view, when I did all my testing, it all worked okay. So hopefully it continues to work throughout the session. But what we want to really look at here is I've created effectively a checklist, and checklist is I guess one of a better term for what we're providing. It's really a run through of a couple of key issues that we want to deal with in this particular space. So we're going to look at the trustee powers. We're going to look at the pros and cons of reversionary pension. I'll put my hand up and declare sort of where I sit with regards to reversionary versus non-reversionary. And it's not sort of any controversial position as such. It's more in the practical sense of things, and a lot of questions around timing. What we've tried to do in the presentation as well is, because we know that you'll have some questions along the way, and we'd love you to shoot those through. But I've also tried to address a number of the questions by raising FAQs as we go through the presentation. So what I really want to, I guess, address to start with is that 2017 particularly was what I would classify as a watershed moment from a death benefit point of view for self-managed super funds. So clearly we had a transfer balance cap and a lot of other key issues addressed from a government point of view, but we did see a fundamental change in death benefits from that time, from what were commonly held practices in the SMSF industry, particularly around things like the capacity to take a commutation, and the timing of that commutation would be reclassified as a lump sum withdrawal rather than death benefit payment. And we've seen effectively the abolishment of that, and almost like a clarification of the ATO's position of how we should have acted before 2017. So it gives us a good indication of how we have to operate moving forward. But in addition to that, with the transfer balance cap and the capacity to roll over death benefit pensions, we have greater clarity now around how things operate. So I think the rules are quite clear about death benefits, but there's still, obviously, if you haven't dealt with it, if you haven't got clients who've passed away in that 4-year time frame, 4 to 5 year time frame, then you're having to revisit a space that you haven't been in since the laws have changed. So it's always good to have a bit of a refresher. So when it comes to those issues, we have to work through them. And then the key to me with all of this is the decision-making process. So what decisions are being made, the style of benefit payment that is being taken, how regularly are our decisions about how we want our death benefits treated, how regularly are they being reviewed, and then who's enforcing those decisions. So the trustee side of things is really critical in the death benefit space, and we will spend a bit of time focusing on those control issues. because one of the things, and correct me if I'm wrong, Jason, but one of the things as an administrator is you have your preferred deed and your preferred deed provider, but you'll have funds that come to you and their deeds are quite different in their approach. And so, there is some, real need to review them to see what's possible in the death benefit space.
Yeah, that's right. I mean, we do like to let people have the deed that they want to use, and if it's old, we'll certainly nudge them in the way of an update. But yeah, we would have probably within our funds hundreds of deeds, 600 or 700 deeds. So yeah, absolutely.
And look, and to be fair, I suspect that most lawyers will suggest that their deed is the best. That's not an uncommon practice, and I suspect some of them are right with reference to that, and so it's a happy balance in between that space. So I kind of wanted to address this from a how should we think about estate planning and the payment of death benefits, and one of the critical things is this whole concept of don't postpone it until tomorrow. And the title of the presentation, Death Benefits, planning for the inevitable. It's one of those things that I remember, and those that have been to my presentations before around this sort of subject matter, is I always originally, as a youngster, many years ago, struggled with the concept of talking about death benefits with SMSF trustees. But it is one of those areas where you need to approach it from the reality that everybody is going to pass away. We don't know when that's going to occur in most circumstances. So we have to start planning right from the very outset. And so part of the checklist is to address some of those key issues right away, because we get carried away or caught up in the whole fund establishment process. But as important as the fund establishment process is to an SMSF, establishing the estate planning part of it is as critical, because once that first money hits the account, then we have the capacity to pay a death benefit, and we need to be prepared for that. Existing plans may be ineffective or undesirable tomorrow. Now, look, I always try to personalise or bring some form of reality to these presentations. And again, those that know me and have listened in, they know that over the past few years, my wife and myself separated, but we still have a self-managed super fund together. And I know I promised at our separating members presentation that I'd get on with that, and I haven't quite got to that point yet. But what that actually means is we're still members of the fund. So I know that my death benefit nomination still has her name on it, albeit that it's not a binding nomination, and her nomination still has me on it. So, whilst we don't meet the definition necessarily of a spouse in the sense that we've separated, we still are spouses because we're not divorced. And that is a key issue from a self-managed super fund planning point of view, is if there is relationship breakdowns, what action are you taking to ensure that death benefits are going to the right place? And I suspect, like myself, you always focus on everybody else's scenario as a real sort of address everybody else's before you address your own. And so for me, it's pretty key that I have to address those issues. And so, when we're looking at this for our client's point of view, are we also looking at it from our point of view as well? Now, Jason, I see we've got a question come through already. Do you want to just shoot that one through to me?
Yeah, so a question from Daniel. Daniel, thanks for that. He's basically touched on the fact that theoretically you should only have 2 payments out of the fund for a death benefit. So he said someone with many interests, pension and accumulation could theoretically have much more than 2. He said 12 lump sums here. What do you think is the rationale for this rule, and do you see any changes coming?
Yeah, look, that's actually a really good question, Daniel. Thanks for shooting that one through. And I'm going to touch on the lump sum, the interim and the final one through the presentation. It's a really good practical question, because I've had and I see you've just followed it up, that auditors won't breach the payment standards. So well done on finding some fairly flexible auditors in that regard. But I actually appreciate your commentary, because the dealings that I've had with auditors in this space as well is that most people do take a fairly practical approach to the payment of death benefits. Now, clearly with self-managed super funds, where we do have multiple interests, pension interests and commutations from pension interests are almost excluded from that lump sum withdrawal point of view. The ATO came out with some commentary in the post-2017 reform, saying that the interim and final lump sum is about clearing that original benefit. But if you're then taking ongoing lump sums, for example, from a pension interest, that they don't count. But of course, that doesn't address the fact that if you stop all those pensions piecemeal, so one by one, and pay it out from an accumulation interest as such, then you are paying more than the interim and the final. So the legislation ultimately goes back to pre-SMSF days or early SMSF days, where the concept is you can get a first payment out there because you're trying to appease the beneficiaries and receive some sort of payment out, and then you can clarify and finalise all of your liabilities and then make that final payment. I think you're right in that it's not an area of high demand or high risk from an ATO point of view. What the ATO are really trying to address in many of these instances, and I appreciate that it's a regulatory issue, but what the ATO are really keen on is making sure that you are not delaying the death benefit process. So you're not just paying it out piecemeal so that you can potentially offset assets at a better tax rate or at a better price, or whatever the case might be from a liquidation point of view. So it really is addressing the whole concept of trying to do things in a timely manner. And look, whether or not the government ever looked to change the regulations, I'm not sure of that as such, but clearly to this point in time, in the 20 odd years that I've been doing it, I've never seen it raised as a major problem, and I've certainly seen it happen on more than one occasion. So it's a great question, Daniel. Thanks for shooting that one through. So we always need to understand that things change, and we need to be ready for those changes as they occur in people's lives. So the concept of having a plan B and potentially also having a plan C is fairly relevant. So look, let me just rush through a couple of the key things that I want to address before we get into the practicalities. And one of those is really that a self-managed super fund is certainly the most powerful distributor comparative to other sort of superannuation providers, because the members, the beneficiaries, are intrinsically linked. Therefore, there's that relationship issue that you have to deal with there. But you've got greater capacity, and we'll touch on binding nominations and that as we go. And of course, what that leads to is that we don't have access to the old Super Complaints Tribunal. So we've got this Australian Financial Complaints Authority in place now. Self-managed super funds don't have the access to that authority to be able to challenge, or the beneficiaries don't have that capacity to challenge the trustees because of that closely held nature, which means that the fact that trustees have the capacity often to use their trustee discretion, it will lead to disputes, and those disputes can often lead to court cases. And when I started in this space, we used to always talk about Katz and Grossman. It was the death benefit that was referenced in the self-managed space, but now there's this huge number of court cases all targeting different areas. And so you don't want to be part of my presentation. You don't want to be one of those sorts of funds. So as much as we can get right in the establishment process and the ongoing process resolves a lot of the issues from a beneficiary point of view and a trustee point of view later on. So we know that the payment is a payment from a super fund after the death of another person, and that person was a member of a fund, and we can pay the benefit as a lump sum, a pension, or a combination of both. And as the question alluded to from Daniel, that lump sum is targeted as an interim one and then a final payment as well. It is the only compulsory cashing requirement of the SIS reg, so we have to make sure that death benefit is paid out, and it must be cashed as soon as practicable. Now, one of the questions that I haven't addressed specifically as a question, but what is as soon as practicable? It is a little bit of a how long is a piece of string question, and you'll hear the likes of myself and others in this space talk about a 6-month rule of thumb, and that 6 months has been addressed historically by the ATO and by Treasury in different legislative references to exempt current pension income and other matters. Well, the reality is you obviously want to tidy these things up as soon as possible anyhow, and you want to have good reason to delay the processing of the death benefit. and we'll talk a little bit about things like probate and that throughout the presentation. But largely, you want to take action as soon as you can. And effectively, and I saw this somewhere just before Christmas, the ATO don't consider grief to be a reason to delay the process. Now, that's the harsh nature of the regulator in a lot of these sorts of instances. But of course, the health of the surviving trustees would be one of those areas that could potentially delay the payment of the death benefit. And of course, the concept that it be cashed means that we do require a physical payment. So I'll address that a little bit as well. And then who can receive it? So basically, one or more of the members' dependents, their legal personal representative, who is the executor of the will or the administrator of the estate of the deceased person, and then barring the capacity to find anybody else through the usual death benefit channels, to any non-dependent where a dependent or LPR can't be identified. So again, a lot of that I think comes back to the process that we go through with the self-managed super fund and the relevance and importance of having a will, not necessarily to dictate how benefits are paid, but to identify legal personal representatives and the like in the SMSF space. To me, it's critical that these things go hand in hand from an estate planning point of view. So look, I do provide this bit of a chart for you from a dependency point of view, and you will get a copy of the presentation following the completion of it today. So I guess some of the key things is that from a nomination point of view, we can only nominate a cis dependent to receive it. So your spouse, either as a de facto or married spouse, is a cis dependent, whereas your former spouse is a tax dependent but not a cis dependent. So ultimately, when it comes to the taxation of super, your former spouse can still receive your death benefits tax-free, but they can't receive it directly. So, there may be some reason why you want to leave money to a former spouse, and often people scoff a little bit when I make that comment. But if there is young children involved, it may be that you are distributing benefits to the former spouse by the estate to distribute or to potentially hold on to for those children. That might be a reason. I can't generally think of too many other good reasons to leave money to your former spouse once you have actually separated. But this table provides a good outline of who can receive or who can be nominated, and then who can receive pensions, because it's fairly restrictive as to who can receive a pension in this space as well. So from that, we want to work into it. So that's kind of like the overview of the death benefit process. But now I want to really work through the checklist that, from a practical sense, from an administrative sense, I've looked at all these issues over my time, and we discuss them regularly here. We discuss them with the client managers, the senior client managers, as to the processes we need to address, the questions we need to indicate when we're dealing with our clients. And Jason, if I can just ask you, as a senior client manager, I assume you've done a death benefit or two in your time?
Yeah, I've got a couple on the go at the moment. So you mentioned you don't always see them, and I've been pretty lucky over my time to not have done as many as I probably could have, given the aging sort of demographic. But yeah, got a couple at the moment, unfortunately, and they probably are starting to ramp up, unfortunately. As I said, with the way that the industry sort of travels, I guess. It's sort of inevitable. But
absolutely. And when you're talking about a 20-year-old industry, or just over 20-year-olds, and given a lot of those original entrants to SMSF were in their early 60s or whatever, then we do have that aging demographic. And how many of the death benefits you process all follow exactly the same process?
Oh, look, they're pretty much all different. It'd be nice if they went in a similar fashion, but yeah, hold ups for all sorts of different things, and we'll touch on it a little bit from here. But very, very unusual to have two that are the same, a bit like a snowflake team.
Yeah, no, very, very good. And look, and I think that's the thing. I think that's the key issue, is that because most of the time, I mean, pensions are pensions. Account-based pensions are relatively straightforward. You've got a starting balance, you've got a minimum, you've got all those sorts of things. So they're the rules there. Contribution rules are largely pretty similar. Death benefits the rules are very simple in the sense of who can receive them, but the process is going to be quite different for every fund because of the trusteeship, because of the nomination styles, because of existing pensions, because of, as per the original question, someone with multiple pensions and accumulation. So all of these sorts of things transpire to make the process fairly comprehensive one that we have to contemplate right from the outset, as I said before. So, when I talk about the checklist, I talk about whether your self-managed super fund clients got the following matters under control. Have they got a will? Now, I always address this to say that superannuation can avoid the will, so we don't have to pay our benefits to the estate. But the key to the will is that it can identify our legal personal representative, and so it's a critical document from a potential trustee point of view, not necessarily from a benefit distribution point of view. Albeit that in certain circumstances it might be the appropriate vehicle to distribute the money. And then our nominations, as we get through that process, will direct the money to our estate, and then it can be distributed by the will. So really critical part of the SMSF establishment process, that once people have got money in super, that they ultimately have got those other legal documents in the background supporting them.
It's probably worth mentioning, because a lot of clients, a lot of advisors probably already know, but clients may not, that by default payments won't go from super to the will unless specifically requested. So that is something that quite often comes up, and of course the will forms the basis for death benefit planning.
Yeah.
But if super is structured in a certain way, it'll bypass it. So a lot of people, I think, still assume that by default super goes to the will on death, but of course that's not the case.
Yeah, and look, it's a great point, because when you start to explain that, you can start going down a rabbit hole in that regard. And so obviously our key point there is that we will often, or not often, we will always refer our clients off to seek the appropriate advice in that space, as I address in my checklist process coming up shortly. So have they completed nomination of beneficiaries? So do they have an appreciation for who the beneficiaries are? That table that I previously put up there, have they nominated or completed it, whether it's binding or not? Is there something that can potentially direct the trustees in the event that the member passes away? Because if nothing's been done, then ultimately, whilst we're checking the deed is effectively going to give the power to the trustees to distribute the benefit as they see fit, and that's obviously can have ramifications for others. Have they considered insurance in their self-managed super fund? So this is one that I've certainly banged on about a lot over the last sort of 10 to 15 years, particularly pre-2017. We had this this anti-detriment concept that a lot of people sort of focused on in building up reserves in their super to pay out this additional death benefit. To me, it was a bit of overkill in the SMSF space, because it very, very rarely did it actually produce the outcome that people wanted to. But there are other insurance issues associated with death benefits, such as the future liability to pay a benefit tax deduction, where if a member passes away before age 65, there is often the capacity to claim a significant fund deduction, which can offset large tax liabilities, and it's almost an exclusive deduction for self-managed super funds. So the concept of having insurance in super, one, it's a regulatory requirement to consider it, but then when people do consider it and have it inside their super fund, there are potential tax ramifications and tax benefits associated with holding that insurance in the fund. So certainly one of the key issues to the death benefit payment process is making sure that if there was insurance, that insurance proceed has been received. And back to Daniel's question, with the interim payment, you might be able to pay out what you've got in the fund, but if you're waiting on the insurance proceeds, then you can't make a final payment until all that's received as well. So a key issue being the insurance. Does the deed accommodate membership and trustee requirements? Now that's a general statement around the concept that I've seen deeds, and probably many of you have seen deeds that say that membership ceases on the death of the member. Now, you'll hear different commentary on this. My concern with a deed that says membership ceases on the death of the member is not so much about the capacity for the death benefit to be paid out, but more so for the capacity for the legal personal representative to be appointed, because the way that the law is structured under Section 17A, the definition, it says the legal personal representative of the member, so when the member has died, can act as trustee of the fund. Now, if you are by definition no longer a member because the deed dictates that you're not a member, now that's kind of, I don't know what the position would be in a court case, because if you've got a balance there, then they would argue that you are a member, but you want to take away the capacity for people to argue the point. And so therefore, you're better off having a deed that says membership ceases on the payment of, or on the final payment of the member's benefit after they've passed away. But similarly with the trustee side of things, the legal personal representative is not an automatic appointment. It is a possibility. So the word can is within the legislation. So we can appoint the member's legal personal representative when they pass away. We don't automatically do it. And so what we want to make sure of, particularly in blended self-managed superannuation funds, but arguably now in the 6-member self-managed super fund environment where we've just got larger families, is you don't want a certain portion of the fund, and let's call it like it is in this instance. You don't want the kids to overpower the surviving parent to make a decision about the death benefit where trustee discretion applies. You don't want that sort of power with any group within the self-managed fund. So if you can mandate the appointment of the legal personal representative to then represent the deceased member, then some people will want to take it that far. And so all of these sorts of things are going to be critical as to how they're written within the deed, because the standard set of rules is going to follow the law, and it's going to use the word can. So the LPR doesn't necessarily need to be appointed. So we need to make sure that people get those processes right. And then have the taxation implications of death benefits being explained to the members and to their beneficiaries. Now, that's I wouldn't be suspecting that people would need to start explaining the taxation ramifications of death benefits to children who are under the age of 18 or whatever. But I think particularly when we're talking about aging parents and adult children, then those adult children need to appreciate or have an understanding that you've got 2 levels of taxation that are going to apply. You've got, albeit that they say there's no death tax in Australia, that there is the lump sum withdrawal tax for a non-tax dependent, 15% or 17% with Medicare. But then there's also capital gains tax if the parent has passed away or the fund has passed away and it's not exclusively in pension, then you've also got the tax liability on the sell down of the assets to contemplate. So it's really important that we have those discussions with the beneficiaries so they're aware that that $1 million portfolio is not actually a $1 million portfolio. It might be closer to let's call it a 900,000 less 15%. So between that sort of $750,000 and $800,000 liability. I'm not sure how my maths is going early in the new year, but these are the conversations we need to be able to have with people along the way. So
your son just turned 16,
18,
Tim. Sorry, so I assume that was part of the 18th birthday celebrations, just running through the sister eggs and.
I did, correct. I did explain to him that now he will pay tax on the death benefits versus having them tax-free, so he's missed his opportunity. And we did speak about him joining the self-managed super. It was a very short conversation. And needless to say, he is in another fund for his new employment. So look, let's look at a little bit of a checklist from a concept point of view, and bear with me. This looks a little bit all over the shop, but there is method to my madness in the way that we talk about this. And this is the introductory piece that we want to have, or introductory conversation that we want to have with our clients. So does the member have cis dependence? So, one of the key issues that we're going to come across is that we're going to have our single member funds. So I touched on 6-member funds before, who clearly are going to have, in most instances, large number of dependents to contemplate. But single member funds are a very popular source of super funds. So do they have cis dependence? If the answer to that question is no, then does that member have a will? Becomes such a critical question at that point in time, because if the answer to that is no, then we really need to push these people off to get the appropriate legal advice, because having a vehicle to invest the superannuation in is fine, but then in the event that they die, what is actually going to happen and how long is that death benefit process going to take. And in the very early days of my administrative experiences, I saw one of these things just drag on for years because it was a single member fund and it was disputed as to whether or not there was any cis dependence. And that's what you don't want to find yourself being accommodated by in the death benefit planning process. So
one of mine currently, unfortunately, is pretty similar, trying to find appropriate dependents, and there's some squabbling going on. So
and look, and this is the thing, is most I shouldn't say most, but a lot of families are happy families until an event occurs. And often, particularly one of the things I addressed in the introduction, or the concept around launch of this webinar, is that there will often be family disputes, and often that point of family disputes is when the glue of the family or something like that comes undone. And if that member passes away and things start to fracture, then it can create problems. And so there's some of the issues that we try to address. But if we do have a will, we've then got a legal personal representative, so we can at least then start the process of planning from a nomination point of view. So that's where we would go to first with our single member funds. Have we got cis dependents? Yes. Is the member at or past preservation age? So if we're at or past preservation age, then or if we're not there, then we also need to make sure that we've got the nomination planning process underway, whether it's binding or non-binding, and I'll touch on those both in a moment. Of course, if they are past or at preservation age, then do we need to look at our pension planning? Now, are we doing pension planning and or nomination planning? So are we nominating based on the number of interests? So are we reverting one pension? Are we nominating our accumulation balance to go elsewhere? What are we undertaking? Because a single line nomination of beneficiary is probably not going to cut one single person. And that's where I sort of come in on this whole concept of reversionary versus non-reversionary. Is in a plain vanilla superannuation fund where survivorship is going to be obvious and other things, then a lot of these processes aren't as critical. But I would suggest that nothing in today's environment is plain and vanilla. And so we need to make sure that we've got everything under control. So to me, it then comes down to this concept of, are we doing nomination planning or are we doing pension planning? So if we start with the nomination planning piece, we've got our two options. We've got our binding nominations and we've got our non-binding nomination. And then we've got our lapsing and our non-lapsing nominations. So this is a critical issue for self-managed superannuation funds. And the questions we have to address in it is, when is a non-binding nomination appropriate? When is a non-lapsing nomination appropriate? And what value does a legal personal representative have, coming back to some of the comments that I made on the previous slide. So clearly, if you've got a non-binding nomination, then the trustees will have that discretion of how to pay a benefit out. So that gives greater, I guess, desire for the legal personal representative in most instances to be appointed at that point in time. If you've got binding nominations, then whether or not the legal personal representative is appointed as trustee of the fund, the remaining trustees should be acting in accordance with that nomination, and any action that they take outside of that is likely to result them going to court. And what we've seen from the historical cases is where there's been a valid binding nomination in place and the trustees have paid otherwise, trustees have lost, right? So most of the cases that we see, the problems is that people who were aggrieved by a binding nomination are not happy with that, and they go and challenge it and say we should be able to have this discretion or whatever else, or we think this nomination is binding, or whatever the case might be. So the LPR does have a fair bit to play, I think, particularly down that non-binding line. When is the non-binding nomination appropriate? Well, again, I would come back to the case here of the vanilla self-managed superannuation fund, where there is no other spouses. There is unlikely for a distribution to go to children, or no likelihood for the distribution to go to children, or in the instance where it's all going to go to the estate. So there is no one effectively left to challenge it, and so the benefit is going to go across to the estate, and the trustee is pretty comfortable. The surviving trustee, or the LPR in this instance, is comfortable in making that decision, and so we then have to address the issue of binding nominations and the concept of lapsing versus non-lapsing. And I wanted to raise this, and again, in the build-up to today's webinar, I addressed this in my education update. This whole Hill versus Zuda Proprietary Limited, which was held in the WA Supreme Court last year, where effectively there was a non-lapsing binding death benefit nomination, and the daughter challenged the validity of that, and to suggest whether or not the precedent that had previously been set by a number of other cases that suggested that self-managed super funds don't have to follow the law, whether that was necessarily correct or not. And what that found, or what that situation found, was that a self-managed super fund, what the Supreme Court found was a self-managed super fund is not subject to the law, so therefore they are subject to their governing rules and what's within the deed, unless the High Court rules otherwise. So basically, they basically made the position that unless the High Court overrule us, then binding death benefit nominations can be non-lapsing and don't need to be in accordance with the way that the SIS Act and regulations are written. And of course, where we are now is that in 2022, it's already started. This case has been referred to the High Court. So the daughter has actually taken it to the High Court for consideration.
So that means, what are the implications of that then? Are we talking we've moved to this sort of era of potentially having non-lapsing, and is that sort of in jeopardy with this High Court decision then, or?
Well, arguably it is. You would think that the High Court, the High Court, you would think that they would need to rule, because the parties for the I never know the affirmative and the opposite from the affirmative in this situation, but those arguing against the lapsing or the non-lapsing nature of binding nominations are saying that yes, the SIS Act says that these rules don't apply to self-managed super funds, but that we're ignoring other parts of the law that impose other requirements. What the High Court is ultimately going to have to come out and say is that those other parts of the law are either relevant, right? And therefore, if they are relevant, then self-managed super funds would have to apply the law as it's written to them, or they would have to have a binding nomination. It would have to be in agreement with not only the way the deed's written, but also the way that the law is written. So potentially that would cripple the concept of non-lapsing binding nominations. Or the High Court will just go along the lines of how all the courts, all the Supreme Courts have gone so far, and say that, based on what the ATO said back 10 plus years ago, a self-managed super fund can have a binding nomination that is done in accordance with the deed. So if they go down that path, then there's nothing to see here, and we can continue on with binding nominations. They can be non-lapsing. They don't need the same witnessing requirements and all those other things as an APRA fund or otherwise.
Which is probably what we'd be hoping if we're going to sort of pick sides in a legal dispute.
Yeah, if we're trying to pick sides, we're probably picking that side, because that would be the less administrative nuisance for the SMSF industry. Because if the High Court go the other way, then there's a lot of work for a lot of people to review all of their binding nominations and potentially turn them into lapsing nominations. And so that's a big communication piece. So we'll be keen to address that and get that out to all of our newsletter recipients as soon as we hear something. But it is a good and interesting piece to be mindful of. And so the whole idea as to whether you go binding or non-binding from a nomination point of view, and then whether you go lapsing or not, really is always going to be circumstantial for the fund. And the pros of lapsing means you're reviewing it regularly. The pros of and the cons of non-lapsing, for example, are that somebody who you don't want to receive your benefits may receive it because the nomination didn't lapse and you passed away, and they then receive their benefit. And we saw that, I think, albeit that it wasn't necessarily a binding nomination, but we saw a similar sort of scenario in the Conti, again, in the WA case. So all of these sorts of things are fairly relevant. So who are there's a number of the key considerations. Who are the remaining trustees? It's always going to be a key consideration when determining the nomination process. Who is the deceased LPR and how can they be appointed? So again, that's going to come back to the deed. Does the nomination achieve what the member wants? And again, that's always going to be pretty critical potentially when we get to the pension phase as well. And are we regularly reviewing our nominations? So all of these things are pretty critical. And I just want to highlight that today's session is recorded, so it will be available afterwards on demand and eventually also on our website for you to re-access it. So, it is very conversational and a lot of points being raised in the time frame that we have. So, everyone will have the opportunity to go back and listen to it again. So all of these considerations we have to take into consideration. Shouldn't have said it so many times in the one sentence there. But again, coming back to checking the deed is a critical issue as to what does your deed provide for in the nomination space. And I think that's one of our key areas. And then from the pension planning point of view, we touch on the key issues of reversionary versus non-reversionary. So the whole concept of trustee discretion. So when we are planning our pensions, as I said, from preservation age, we've got account-based pensions and we've got transition to retirement income streams. Now, most of us will still put these two products together in the sense that they are exactly the same, other than the TRIS has the 10% whilst it's in accumulation and it doesn't have the exempt current pension income. But the bonus of the TRIS now, and this took almost 2 years after the 2017 changes came in, the bonus of the TRIS now is that you can make your TRIS reversionary, and death is a condition of release, a trigger point to make it go from a TRIS in accumulation to a TRIS in retirement. So again, from a planning point of view, that can be really beneficial because you're not having to cease the TRIS and start an account-based pension, because if you cease the TRIS, it would then merge that money in potentially with accumulation if you get your timing and things like that wrong. Again, albeit that pension interests are always separate interests from a death benefit point of view. So you've got your account-based pensions, you've got your transition to retirement income stream, so you need to do your thought process there. And then there is also your concepts of who am I paying a lump sum to? Am I paying a lump sum? And are there children involved, and are we going to pay a child pension? So when I look at these issues, what I tend to address here is the pros and cons of reversionary versus non-reversionary. And I guess in a nutshell, for me, the pros of a reversionary pension are certainty, right? So I know, Jason, you were saying that you had this conversation yesterday about trying to explain, that the transfer balance cap isn't the be all and end all of reversionary pensions.
Yeah, obviously it's a big factor and it can have its benefits, but you'll touch on it here. Reversionary versus non-reversionary now is more around flexibility and what you can do when someone passes away, as opposed to maybe in the previous regimes where it was a sort of a no-brainer to have it as reversionary.
Yeah, and I think and so since 2017, the transfer balance caps come in, and so we focus on this 12-month delay in the reporting. It was not actually a 12-month delay in the reporting. You still got to report at the same time frames you do with everything else. It's just 12 months until it's actually credited to the recipient's transfer balance cap. So there is some level of certainty around valuations for transfer balance cap purposes. But again, in the SMSF space, where the members and trustees are one in the same, the capacity to make a discretionary decision to start a pension immediately upon the member's death, whilst you don't have potentially 12 months to act on a commutation, which is what the reversionary pension gives you, you can still time things from a valuation point of view with that commencement. So when I argue the points of reversionary versus non-reversionary, my main point of arguing against reversionary pensions is that they impose a mandatory minimum pension obligation for the year. So irrelevant of when the member passes away, you've got to pay the minimum for that year, versus a discretion where the pension effectively ceases on death. then there is no pro rata commutation requirement for that death benefit and prior to the recommencement of the new pension. So it can actually be one of those situations where if somebody passes away and they haven't paid the minimum, and we talked about the emotional turmoil earlier, if they haven't paid their minimum and we tick over 30 June, then we're not focusing now on our death benefit issue. We're now focusing on the fact that we failed to meet the minimum pension standards. And by failing to pay the minimum pension standards, we lose the exempt current pension income associated with that year. Now, again, in a practical sense, we've got this quandary, and it's not necessarily covered by the legislation. It has been addressed by the ATO, but whether that's sufficient or not. And they've said if you fail to pay the minimum, then you can recommence that death benefit pension from 1 July the next year. So they're not mandating the payment out because that money has gone back to accumulation. But that's not what necessarily the law says. So I think it's one of those areas that you've got to make sure that you're paying your minimum pension. So, reversionary versus non-reversionary has always got its pros and cons. What I would say when we're talking about some of these other issues is that you've got to contemplate things like Centrelink and that as well, which may have ramifications on the way that these pension operates. So then when you look at taking lump sums, again, because everybody's measured under the transfer balance cap now, it may actually be in the best tax benefit for the family of the deceased to take the money out of superannuation as a lump sum. Because if we contemplate that most self-managed super funds are two-member funds, and the majority of those are spouse-based funds, then we're largely going to be dealing with death benefit number one, which can then easily be paid to the spouse. But then we're dealing often with death benefit number two, which is when the spouse passes away. And if we have gone and wound back their pension to put it in accumulation to move the spouse's pension over to the surviving spouse, we've still got all that money in super. And then we've got an inevitable death benefit, which is likely to be paid to non-tax dependents that we have to contemplate the tax liability. So, it may be conceivable that the idea of paying lump sums to a spouse actually has greater tax benefits for larger superannuation funds when the combination of both members' benefits exceeds 1 times the transfer balance cap. For those with smaller balances, the capacity to have it all in there and then have a combined benefit payment of a lower amount later might actually be okay because the spouse doesn't have such a drawdown requirement to be considered. So I think all of those sort of issues are things to be mindful of. And the concept of child pensions, again, you are restricted by the transfer balance cap and how much you can actually pay out to a child like you are with the adult. But it can be beneficial in that you can potentially pay the pension to the children up until age 25 and then pay out a lump sum tax-free death benefit to them at that point in time. So, does the planning contemplate or comply with the transfer balance cap? That's one of the issues that you need to be mindful of. Where will commutations occur? So will they occur from the deceased benefit or from the spouse's benefit? So what are the processes for winding back existing pensions? And then what roles does insurance play in the pensions? And so this is another one of those key issues that's been addressed historically by the ATO. But if you have a reversionary pension and you have insurance proceeds within it, then that insurance proceeds won't count towards the transfer balance cap because at the date of death, there's no insurance proceeds on the file. Whereas the death benefit income stream started by non-reversionary will actually count towards from a transfer balance cap point of view. Now, again, we're actually addressing the question of how many people have insurance still when they're paying pensions, and now that might be more likely in a TRIS environment. So all these things need to be weighed up in the entirety of the conversation around what we're doing with our clients. So they're the matters that I would be addressing. So what I want to do quickly for you then is run through and just sort of tie in a couple of those questions. These are the ones that we've had frequently before to make sure that I've covered off on those points. Can a reversionary beneficiary be nominated when the pension commences? Absolutely. That's obviously plan A, rule A of how we want to approach the payment of pensions. does the pension have to be set up as reversionary? So this is one of those key issues that it's going to come down to check your documentation, right? So the ATO have historically addressed this a few times, and many years ago they addressed it and said that a binding nomination would suffice to make a pension reversionary. They ultimately backflipped on that in 2017. And so realistically, the capacity to change the terms of the pension are going to come down to the existing terms of the pension. And if you've got a reversionary pension in place or a non-reversionary pension in place, what other actions do you have? Do you have Centrelink? Because by taking out a pension that's not reversionary and changing it to reversionary, does that mean you've got a new pension for Centrelink purposes? And might that impact your pre-2015 rules and other grandfathering requirements? So all of those sorts of issues, it is obviously much easier from an explanation point of view to say you've got to stop the pension and start it again, but it also can be an additional set of paperwork and an additional hassle to do that. And so if you can just make a nomination, then that would be ideal in certain circumstances. So really it's a matter of checking the paperwork. And probably the most common question that we get asked and that I've always been asked without really having the absolute capacity to answer it is, if there is a reversionary pension and a binding death benefit nomination, which one takes precedence? Well, arguably, and again, I can only follow the regulatory point of view, but also conversations I've had with others, is if you have a genuine reversionary pension, which is a contract to pay the pension for the life of the surviving spouse, then there's ultimately no death benefit to be paid, and therefore the binding death benefit nomination doesn't kick in because there is no payment there. But if the pension documentation is not watertight, if there's nothing really suggesting that it's reversionary other than a poor memory or something like that, then you would argue that the binding death benefit nomination is more solid in that respect. But of course, what you will see more of, and going back to the scenario of having multiple pensions and accumulation, is you might get this combination of reversionary pensions and binding nominations where you have to be specific about which interest those nominations are over. And that's where you're really starting to head into a fairly big legal minefield, and you want to make sure that you get the estate planning right in those instances. Do the trustees need to wait for probate before paying the death benefit? So I'm going to give a very short answer to this, and then I'm going to throw to Jason for a comment on this as well. So the short answer to this is that no, the trustees don't need to wait for probate before paying the death benefit. But Jason, from a practical experience, we see other things occurring quite regularly.
Yeah, that's correct. So, as you mentioned, not required, but from a practical point of view, it's not uncommon for assets to be, I don't know if frozen is the right word, but let's say frozen for the purposes of this example, by the institution that carries them. So whether it's a platform or a bank account, they will actually say, no, we're waiting for probate before we transfer these assets or these funds.
Yeah,
it's cash. So it can drag on. That's probably the main delay that we see from moving investments out of the fund, is because they're saying, no, we want to wait on probate. And look, they're probably entitled to. They want to make sure everything's signed and ticked off. But yeah, will cause a delay.
Yeah, and look, and I think that's a good point to be mindful of, is that the concept that trustees have ultimate discretion and can pay a benefit out, and because the legal personal representative doesn't need to be appointed in most instances, then probate is not a key issue as such for the self-managed super fund. But particularly if the deed is compelling you to appoint the legal personal representative, then you may, in those instances, be required to wait for probate to have a definitive position on who the legal personal representative is before you can appoint them. And that's why when we talk about this as soon as practicable, well, if probate drags on, then you might not be able to pay that benefit out within that 6-month period, and it's going to create a longer death benefit process to be mindful of. One of the questions, we perhaps don't get this asked too often, but you will occasionally at some trustees.
No, it actually comes up a fair bit.
It does? Okay, so maybe you don't ask me this question as often, which is I'm grateful for. What if two members die at the same time? So, in this let's say this unfortunate situation where two members of the same fund have passed away, you're basically reliant on state laws and that around who has passed away first. Now, the greater reality is in that self-managed super funds you'll hopefully have dealt with some of these things like you do in a will, where you address the concept if someone dies within a certain time frame, how a benefit will be paid. You can have that, and I know that we have a cascading death benefit binding nomination form where you say, in the event that blah 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 predeceases me or dies within a certain time frame, then pay my benefit as follows. But it's always going to be a bit of a tricky situation, because you want to make sure that you haven't had your benefit paid from yourself to your spouse and then cascade to your spouse's beneficiaries, particularly in the sense of blended families.
Is there any truth to the concept of the younger spouse is taken to have passed away first, or does that come back to the state stuff?
The older potentially.
Yes,
Look, again, I haven't got too forensic on this, but my understanding is that in South Australia, there are requirements to try and be very specific as to who has passed away first, whereas there is a rule of thumb concept that the older person passes away first. But of course, that's not superannuation law. That's kind of so it kind of makes it it'll flow through, but it can become problematic. And does a benefit get paid to the estate if the member doesn't have a binding nomination? Well, no, it won't. It'll be up to the trustee's discretion. So if the trustee is a beneficiary, they can pay the benefit to themselves. So really quickly, to talk about the trustee requirements, what I want to, I guess, focus on in this area, and we've ultimately touched on it in concept throughout the presentation to point, but just to reiterate, the actual SISAT requirement is that the LPR can act as trustee from the date of death to the date the death benefit commences to be paid. So this could actually be quite a really short period. So it leads into other administrative issues for the fund, because the commencement of the death benefit, and again, this is why Daniel's question up front was such an important one, because it highlighted the concept of the interim lump sum versus the final lump sum. But the LPR can only be appointed if they're not remaining on as a member in their own capacity. They can only be appointed until that interim lump sum is paid. Similarly, they can only be appointed until the pension is commenced to be paid. So ultimately, if you've got a reversionary pension and nothing else in the fund, then the LPR can't be appointed anyhow to act on behalf of the member, because the death benefit's already been commenced. So it's one of those timing matters. Which means it's pretty important to choose an appropriate executor for your fund and have the right person in place that understands what you're trying to achieve in the super environment. But that the appointment is subject to the deed requirements. As I said, can versus must from an appointment is a pretty critical type of issue to be mindful of in regards to that. But also then noting that these time limits apply. So you want to make the appointment as soon as you can. That appointment might not be able to be made until potentially probate. So there's a bit of a delay in that sense. But then the appointment itself is only for a potentially short period until that interim lump sum or pension commences. And then they must be removed. And so then on the flip side of it, you've got the self-managed super fund potentially not meeting the definition of a self-managed super fund because of membership. You might only have one member left and only a single trustee or something like that, where you've then got 6 months to rectify the definition of a self-managed super fund beyond that point. So you've actually got trusteeship considerations both pre-death, or not pre-death, but pre-death benefit, and then additional trustee requirements post-death benefit that we need to be mindful of. And this is where the corporate versus individual requirements are pretty critical, and the corporate trustee, obviously in this instance where you can have a sole director company, can play a benefit. Did we have a question coming through there, Jace?
Yeah, question from Tiffany. Thank you, Tiffany. Is there a conflict of interest if the executor of the will is also the beneficiary of the SMSF benefits, which would actually be quite common, I would think.
It would be really common. And Tiffany, there was a case, and with so many I can never remember the names of all of them, but there was a case where there was a perceived conflict between the executor of the will and nomination of beneficiaries. And so it's one of those sorts of things that from an LPR point of view, they often will say that there's no conflict if you're already the trustee of the fund, because you've already taken on that responsibility to pay the benefits out. But If you are the executor of the estate, I mean, clearly in some instances, there's always going to be that conflict, but you still have to get over the superannuation law, which requires a trustee to make a decision. And if the sole trustee has passed away, then somebody has to step in. The law provides that that's that legal personal representative. That legal personal representative is defined as the executor of the estate. So there's going to be a conflict. So what is then required is the capacity to ensure that you're acting in the best interest, which is a trustee covenant, to act in the best interest of all beneficiaries, all members and beneficiaries of the fund. So you've just got to be showing that you're undertaking your process correctly there. So it can be a bit of an issue. So some of those questions: who is my legal personal representative? As I said, the executor of the will. When do they need to be appointment? What time frame? I covered off on that quite clearly in the slides before. And then what is the role of the executor of the estate? Well, there's no role if they're not appointed as the trustee of the superannuation fund. What if your executor is already a trustee of the fund, i.e. the spouse? Then it's perfect. It looks administratively messy in the sense that they're being appointed in dual capacity, but they don't have to sign everything twice. They effectively just need to note that that appointment's been made, and then notify the regulator of that, and obviously ASIC as well. If you've got to remove a director, then you need to make sure that you go through all the appropriate processes there. And then once the death benefit has been paid, you need to go through the appropriate removal steps in that instance. So I just want to finish off then with the payment of death benefits, and this is a real quick summary, because this is the stuff that we all should be relatively on top of here. Anyhow, we know that if the benefits are paid to a tax dependent, it's going to be tax free. If it's paid to non-tax dependents, then the tax-free component's tax-free. The tax element at 17% or 15%. So there's no tax if it's paid, no Medicare if it's paid directly to the estate. And then if we've got the insurance that we talked about before, if you've had insurance in the fund and it's paid out to a non-tax dependent, then you have to, if the death happened pre-age 65, you have to calculate an untaxed element. So there's a whole lot of if, buts and maybes to apply that 32% tax rate, but it can apply. And then from a pension point of view, to tax dependents, basically, which is always going to be from a definition of who you can pay a pension to. Basically, there's no tax if either party was over the age of 60. Then there's not going to be any tax to withhold. If both of the parties were under 60, so if the deceased was under 60 and we choose to pay a pension to their spouse who's also under 60, then we have to pay marginal tax less our 15% rebate on the taxable component. And again, I highlighted before, if you've got insured benefit considerations, then when we pay out the lump sum or commence a pension, we can ultimately look at claiming a future liability to pay a benefit deduction, which is a benefit representing the future portion of the lump sum. So it can be quite significant in a self-managed super fund and be far more valuable than, say, the annual premium based deduction, but also in the sense that we can now roll over pensions. You could claim that deduction, the pension, the spouse or whoever could roll their pension to another fund and have that as a tax exempt fund. And then in the 6-member fund sense, you can have the kids who are accumulating use that future liability deduction to offset the tax of the fund. So there are some benefits associated with it there. And from the final point is that from the fund position, we get our deduction, our exempt current pension income deduction once we're in that pension stage. So even if the pension ceases, so in reversionary pension, the pension doesn't cease. In the discretion, the pension will cease, but the ECPI deduction won't cease, right? Unless, of course, we fail to meet the pension standards. So we actually get that ECPI deduction all the way up to the payment of the death benefit. But if you fail to pay the minimum pension because of, say, the reversionary, then you lose that ECPI deduction. So, again, it all comes down to the practicalities of doing the right thing, I think, in these instances. So just the last couple of questions then, can I roll the pension to another superannuation fund? Yes, you can. So this was the big change from 2017. Previously, you could only do it to immediately cash it. Now you can do it and maintain it, and as a separate death benefit rollover form. from a reporting point of view, so that those monies are always kept separate from other superannuation money. So if you've got multiple pensions, then you can ultimately end up paying doing multiple rollovers to the other fund. You can merge those pensions and retain them as death benefit pensions, but not with other existing pensions. And can the death benefit be transferred to another member via journal entry? This is old school kind of 1990s operations. No. So previously the concept was, and when I say concept, it wasn't ever agreed to by the regulator, but the idea was, well, if the spouse is going to receive it, can we just actually do a lump sum and a recontribution back in and then start a pension? The answer to that is no. The money or the assets have to come out of the fund and then be subject to the contribution, which then does lead to the capacity. Okay, well, do we have to sell the shares? Can we do an in-specie transfer? Well, you can do an in-specie transfer, but then this comes down to the chicken and the egg scenario, is that to do an in-specie transfer, you actually have to commute the pension and then roll over those assets. So that does the CGT liability exist? You don't get to keep the cost base of the assets or anything like that. So it's effectively a new transaction. So yes, you can do in-specie transfers, and we see it quite regularly. I had a question just before Christmas.
Do you have the argument that maybe that's multiple payments, which you're sort of trying to avoid?
Yeah, correct. It becomes a thing. If you've got lots of shares, like are they all separate payments? And that's been discussed a number of times over time. And I think you could potentially argue in favour of it, but the system would show otherwise. Probably there. And then the question we've also had a question just come through from Anthony. If you roll over to another fund, are you rolling them in the name of the deceased, or the recipient? Well, then you're rolling it over in the name of the recipient, because the recipient is the death. They're actually in receipt of the pension now. So inevitably, what's happening there, Anthony, is that the spouse is receiving a new pension. It's now in their name. It's tagged as death benefit income stream, and then when it goes over, it's going over in their name, tagged still as a death benefit income stream. When does a minimum pension need to be met in the event of death? As I said, with reversionary pensions, not with non-reversionary. And do all child death benefits need to be cashed out once turning 25? Yes, unless the child is disabled, and then they can continue to receive the pension. So, look, as I said, that was for me and for Jason, it was a bit of a practical guide to the issues we have to address. Not necessarily, here's a death benefit, here's the processes, here's the paperwork, but really addressing all of the key issues from a checklist point of view that we see as important when contemplating death benefits, and ultimately that they need to be addressed right from day one in the SMSF environment. So, Jason, thank you very much for joining me and allowing me to catch my breath every so often.
My pleasure. Thank you for having me, Tim.
And everybody, thanks for joining us. Your CPD will be sent out to you shortly.